Property management is where all of the risk management ideas from the last chapter show up in real life, every single day. Instead of one big decision, like a purchase contract, a property manager is dealing with dozens of smaller but important decisions every month. Screening tenants, handling money, responding to maintenance emergencies, enforcing leases, and keeping owners informed. That means agency duties, disclosures, documentation, fair housing, trust funds, and advertising rules all converge in this one specialty. As a salesperson, you may be tempted into property management slowly. A seller cannot get the price she wants and asks you to just find a tenant. A past buyer moves out of state and says, "Can you keep an eye on the place and pay the landscaper?" A builder has unsold homes and wants you to lease them until the market improves. Each of those scenarios sounds simple, but the moment you are handling rent, deposits, access, or repairs for someone else's property, you are stepping into property management and into a higher risk, more regulated area of practice. This section will help you think like a risk-aware professional. Do I really want to manage property? What skills and support do I need? And how do I structure this side of the business so it is profitable, compliant, and safe for everyone involved? What is property management and what is its purpose? In broad national terms, property management is the part of real estate practice devoted to leasing, managing, marketing, and maintaining property for others in exchange for compensation. The property might be a single-family rental, a vacation condo, a small strip center, or a large apartment complex. What matters is that you are acting for someone else, not for yourself. The property manager's purpose is to provide the owner with the highest possible continuous net return that is consistent with the best lawful use of the property, while at the same time providing tenants with safe, habitable premises and good service for the rent they pay. That balance is critical. If you push too hard for the owner and ignore tenant rights or habitability, you invite complaints, lawsuits, fair housing claims, and vacancies. If you favor tenants and neglect the owner's budget, goals, or instructions, you breach your agency duties and may lose the account or face claims for poor performance. For example, imagine you manage a duplex. The owner wants low expenses and tells you to delay replacing an obviously failing air conditioner. If you simply obey without discussing legal habitability standards and the risk of code violations or rent abatement, you are not managing risk well. A better approach is to explain, in writing, the legal obligation to maintain essential systems and the long-term risk of ignoring them. Recommend replacement and document the owner's decision. That is property management as a professional service, not just collecting rent. Working under a broker and setting up the management platform. Because property management involves trust funds, long-term relationships, and regulatory scrutiny, you must never jump in without your broker's approval and systems. At the national level, state laws generally treat property management as real estate brokerage activity, which means management must be done under a licensed broker, not on your own as a side hustle. Before you agree to manage any property, you and your broker should confirm at least 3 things. First, does the brokerage actually want to engage in property management? Many brokers avoid it because of the extra trust account, audits by the state regulator, and increased liability. Second, does the brokerage have the correct structure? A properly designated trust account for rents and deposits, written office policies for property management, and appropriate errors and omissions insurance that covers management activities. In many offices, the sales E&O policy must be specifically endorsed to cover property management. Some brokers also require fidelity bonds or similar protection for those handling money. Third, does the brokerage have guidance and supervision, not just permission? A broker who doesn't mind if you try it, but offers no training, forms, or review is putting both of you at risk. Strong property management platforms include written policies and procedures for advertising rentals, screening tenants, handling fair housing questions, collecting and depositing funds, paying vendors, responding to emergencies, documenting inspections, and closing out tenancies. Deciding whether you personally should do property management. Even if your license and broker allow property management, that does not automatically mean it fits your skills and personality. Sales and management require different strengths. Sales is often excitement, marketing, and short bursts of intense activity. Property management is long-term, detail-heavy, and conflict-prone. A smart agent interviews themselves with a few honest questions. One question is whether you have good people instincts. Screening tenants is more than reading a credit report. It is also listening carefully, noticing inconsistencies, and reading behavior. For example, an applicant shows up late, is rude to your staff, and cannot explain gaps in employment, but drives a luxury car and flashes cash. A good manager looks past the flash and relies on objective screening. Written criteria, credit, criminal, eviction history, income verification, and references, not gut feel. Another question is whether you handle conflict well. Property managers regularly deal with angry tenants whose AC just failed in July, owners upset about repair costs, and neighbors complaining about parking or noise. If you tend to shut down in confrontation, this work will feel stressful. A good manager can stay calm, listen to the underlying issue, restate the problem, and move to solutions within the lease and the law. You must also be able to balance the needs of owners and tenants. The owner is your client, but landlords who ignore legitimate tenant issues create bigger problems for you. Many experienced managers find themselves reminding owners about tenants' statutory rights and lease protections. Finally, you should genuinely like problem solving. Property management is full of puzzles. Why is there water on the floor? Who is responsible for damaged blinds? What does the lease say about pets? How do you post proper notices? If you enjoy researching the answer and putting better systems in place, you will do well. If you hate details and just want to wing it, property management is a poor fit. Education, law, and professional support. If you and your broker agree that you will manage property, the next step is education. In earlier chapters, you saw how risk management rests heavily on knowing the law, following procedures, and documenting your actions. That is amplified in property management. Before collecting a single dollar of rent or signing a lease for a client, you should learn the basics of your state's landlord-tenant statutes, especially rules on security deposits, habitability, repairs, access, notices, and evictions. In many states, residential tenants have significant statutory protections, including timelines for repairs, penalties for wrongful lockouts, and rules for handling deposits. A common beginner mistake is self-help eviction, such as changing locks or entering and retaking possession without going through proper court procedures. Even if the unit appears abandoned, using your key to enter and remove tenant belongings can be treated as an illegal lockout. Instead, you follow the steps in your state's abandonment statute or file the appropriate eviction action. You must also understand how federal and state fair housing laws apply to rentals. Advertising like "no kids," ideal for singles, or Christian community, is not allowed for covered housing and can trigger complaints or lawsuits. Screening criteria must be applied consistently to all applicants, regardless of race, color, religion, national origin, sex, disability, or familial status. And you should be cautious about policies that have a disparate impact on protected groups, such as blanket criminal record bans. Beyond statutes, serious property managers invest in formal classes and designations. Many real estate schools offer property management courses, and professional organizations provide deeper training in trust accounting, maintenance planning, and landlord-tenant law. Equally valuable are mentors and peer networks. Local or national property management associations often host regular meetings where managers share real-world challenges and solutions, such as how to handle a tenant hoarding situation or a mold claim. Those conversations are often where you learn the "what really happens" side of the business that statutes and forms do not explain. Planning the property management business. Once you decide to manage property, you are essentially running a second business line alongside sales. So you need a plan that covers policies, legal documents, systems, and emergency procedures. Good policies and procedures translate risk management theory into everyday habits. For example, a written policy might require that every applicant be screened using the same checklist: completed application, government ID, proof of income, rental history verification, credit and background check, and review against preset written criteria. The policy should bar on the spot exceptions based on how someone looks or how urgent the owner feels, because those exceptions create both fair housing risk and higher default risk. Another policy might require routine property inspections at move-in, mid-lease, and move-out, with photo documentation and written reports to owners. Systems and software are also essential. Modern property management software can track rent charges, late fees, maintenance requests, work orders, and owner statements, and can integrate with trust accounting. Using scraps of paper and generic spreadsheets for dozens of units is an invitation to accounting errors and missing information. Legal counsel is a critical part of your plan. Because landlord-tenant law is technical and court procedures change, you should have a relationship with an attorney who concentrates on landlord-tenant or real estate law and who reviews your lease and property management agreement forms. Those agreements should clearly spell out responsibilities for repairs, appliances, landscaping, pest control, filters, and how and when you can spend the owner's money without prior approval. For example, your agreement might say that you may approve repairs up to a certain dollar limit without owner consent, but must get written authorization for anything higher. Without those limits, you could find yourself fronting money for a new water heater or roof repair that the owner refuses to reimburse. Finally, think through what-if scenarios before they happen. What if there is serious criminal activity at the property and police are involved? What if a major system fails on a holiday weekend? What if a storm damages multiple properties you manage at once? Written plans for notices, communications, and vendor contacts will reduce stress and protect you when those crises inevitably occur. Knowing when to say no and avoid accidental property management. Not every agent should do property management, and even experienced property managers must sometimes say no. Turning down a risky client or assignment is a form of risk management. Owners who insist on illegal lease terms, no children allowed, who refuse to maintain minimum safety or habitability standards, or who demand that you ignore fair housing or tenant protections should be declined. In those cases, the best service you can provide is a polite refusal, and if appropriate, a referral to legal counsel so the owner can understand their obligations. You also need to avoid accidental property management, where small favors turn into unplanned management without a written agreement. For example, a listing agent might agree to keep an eye on the house, pay the pool service, or coordinate lawn care for a vacant property. If there is a slip and fall at the pool, a burst pipe, or vendor dispute, you may find yourself treated as the manager even though there was no written management agreement. The safer approach is, if you are going to perform ongoing tasks involving access, vendors, or funds, to have a written employment or property management agreement that clearly states your authority, your compensation, and how liability will be handled. If you do not intend to manage, keep your role limited to marketing and sales, and politely decline management tasks. For agents who decide that management is not for them, a strong referral relationship with reputable property managers is still valuable. You can help your sales clients by connecting them with trusted management companies and perhaps receive a permitted referral fee where allowed by law while staying within your own area of competence. Key compliance and licensing concepts in property management. Because this chapter is about national salesperson knowledge, you should be aware of the most common regulatory themes that appear in exam questions and in real practice, even though specific details vary by state. First, trust funds and record keeping are heavily regulated. Property managers typically must deposit rents and security deposits into a broker trust account, separate from the broker's general operating account. States specify how quickly funds must be deposited, what kinds of records must be kept, and how long those records must be retained, often at least 3 years. Those records can include bank statements, deposit slips, ledgers for each owner and property, invoices, vendor bills, owner statements, and copies of leases. Failing to keep proper trust fund records, commingling client funds with company funds, or converting client money to personal use are among the fastest ways to lose a license. Second, unlicensed assistants have strict limits. Nationwide, regulatory trends are clear. Unlicensed assistants may not engage in activities that require a license, such as negotiating lease terms, showing property independently in some states, or collecting rent. For example, having an unlicensed assistant take in rent payments, count the cash, and issue receipts is usually prohibited. Even if it seems efficient, it puts the brokerage at risk of disciplinary action. Third, property management companies themselves must be properly licensed if they are leasing or managing property for others for compensation. A small company that manages multiple apartment complexes for an owner is generally considered to be performing real estate brokerage activity and must operate under a broker license, not simply as an unlicensed consulting firm. Fourth, there are clear rules about returning deposits and accounting at the end of management or tenancy. Many states require property managers to provide a final accounting within a defined number of days, return funds that belong to owners except those needed for known or pending obligations, and handle tenant security deposits within specific timeframes after move-out to avoid penalties or claims. Finally, specialized issues such as marijuana cultivation, medical marijuana cardholders, or other controlled substances often intersect with property management. A key exam-level concept is that criminal drug activity on the premises is generally grounds for lease termination and eviction, but the details of how medical marijuana is treated vary by state. The safe rule is that any drug-related issue discovered at a managed property should be reported promptly to the owner and handled with the advice of legal counsel, not by improvised decisions from the agent. Risk management in everyday property management scenarios. To connect this chapter back to the risk management principles you just studied, consider how the 4 strategies show up in property management. Avoidance might mean deciding not to take on a particular owner, property type, or neighborhood if the risk is too high compared with the potential fee. Reduction appears when you use written screening criteria, standard forms, inspection checklists, and documented communication to lower the probability of disputes and misunderstandings. Transference happens when you and your broker maintain strong E&O insurance. Owners carry appropriate property and liability insurance, vendors are properly insured, and certain risks are shifted to professionals, such as attorneys or licensed contractors, instead of the manager guessing or doing work outside their expertise. Retention is present whenever you accept that some risks cannot be fully eliminated, such as the possibility of a tenant default or a sudden major repair, but you budget for them and have reserves and procedures in place. Everyday examples make this real. If a tenant reports a leak and you ignore it, mold grows. And the tenant becomes ill, you face both property damage and possible injury claims. A risk-aware property manager documents the report, sends a qualified vendor, keeps photos and invoices, follows up, and communicates with both the tenant and owner. If there is later a complaint, the documentation shows reasonable care and timely action. If a landlord and tenant later argue about damage to furniture after a tenant moves out and never returned the keys properly, a clear lease clause and move-out checklist about when possession ends and what return of keys means helps determine who is responsible. In all of these situations, your understanding of agency, disclosure, documentation, fair housing, and trust fund rules from earlier chapters keeps you out of trouble in this practical property management setting. Review summary. In this first section of property management, you learned that managing property is a distinct but related branch of real estate practice, focused on leasing, caring for, and operating property for others. The property manager's core purpose is to secure a steady net return for the owner while honoring tenant rights and providing habitable housing and good service. You saw why it is essential to work under a broker who is set up for management, with an appropriate trust account, insurance, policies, and supervision. You also learned that not every salesperson is suited for this specialty. Property managers must read people, handle conflict, balance owner and tenant interests, and enjoy solving practical problems. Education in landlord-tenant law, fair housing, and local procedures is not optional. It is your first layer of risk management. Mentors, classes, and professional networks deepen your competence. You then explored the importance of planning your management business with written policies, specialized software, clear leases and management agreements drafted or reviewed by counsel, and emergency plans for crises like serious maintenance failures or criminal activity. Saying no is also a valid strategy. You should avoid accidental management, decline clients who demand illegal terms, and refer owners to specialists when you choose not to manage. Finally, you connected back to risk management and licensing themes, trust fund handling and record keeping, limits on unlicensed assistance, licensing requirements for management companies, handling of deposits and final accountings, and the need to involve legal counsel when complex issues such as drug cultivation, foreclosure, or contested charges arise. Together, these ideas give you a framework to decide whether to add property management to your practice and how to do it in a way that is both profitable and compliant. Discussion prompt 1. A past buyer who is moving out of state asks you to just keep an eye on the house, pay the pool guy, and collect the rent for me until they decide what to do. You are mainly a sales agent, and your broker does not currently operate a trust account. What should you do and why? Suggested answer. You should not casually agree to those tasks. Collecting rent, paying vendors, and overseeing a property for a fee is property management and typically requires that it be done under a broker who is set up with a trust account, policies, and appropriate insurance. Because your broker does not do management, you should explain that you cannot manage the property, but can refer the owner to a reputable property management company. This avoids accidental property management, protects your license, and ensures the owner receives competent service. Discussion prompt 2. An owner-client insists that you reject any rental applicants with children because he believes kids will damage the property. How do you respond as a risk-aware property manager? Suggested answer. You must explain that refusing to rent to families with children violates federal fair housing laws that prohibit discrimination based on familial status for covered housing. You should calmly educate the owner that all applicants must be evaluated based on neutral criteria such as income, credit, rental history, and background checks, applied consistently. If the owner insists on illegal discrimination, you must decline the listing rather than participate in a violation. Documenting that you explain the law and your decision to withdraw further protects you. Discussion prompt 3. During a routine visit to a managed home, you discover what appears to be marijuana plants under grow lights in a bedroom closet. The tenant is current on rent and otherwise cooperative. How do you handle this situation from a risk management standpoint? Suggested answer. You should immediately document what you observed and notify the owner. Because drug laws, medical marijuana rules, and lease provisions can be complex, you should recommend that the owner consult legal counsel before any action is taken. You should not threaten the tenant or attempt to remove plants yourself. Instead, You follow the advice of counsel about notices, possible lease violations, and whether to pursue termination or eviction. This approach respects your role, avoids making legal judgments you are not qualified to make, and helps the owner proceed correctly. Closing remarks. Property management can be a rewarding, steady source of income and a powerful way to deepen relationships with investors, owners, and tenants. It can also be a minefield of legal duties, financial risk, and emotional conflict if you approach it casually. This chapter pulled together your earlier learning about agency, disclosure, documentation, fair housing, and risk management, and showed how they operate in the everyday world of leases, repairs, deposits, and trust accounts. As you move forward in your real estate career, remember that just because your license allows property management does not mean you must do it. Your best decisions will come from honest self-assessment, clear communication with your broker, strong education, and a commitment to doing things the right way. If you choose to manage property, do it as a professional, with systems and support. If you choose instead to focus on sales, you can still serve your clients and reduce your own risk by recognizing when a situation calls for a qualified property manager or other professional and making that referral. That judgment, more than anything, is what turns textbook knowledge into wise practice.